morning, everyone. My name is Victoria Esposito. I'm the Advocacy Director here at the Legal Aid Society of Northeastern New York, and it's our pleasure to be bringing you the today's CLE in conjunction with a number of our local bar associations. I see that people are still filtering in, so we'll give you just another couple minutes so that everyone can get in. In the meantime, I'm going to just go over some housekeeping. Everyone should have received an affirmation form and an evaluation form yesterday. We'll be sending the rest of the materials out after the CLE today. If you have a question, please feel free to put it in the chat box. I'll be watching the chat box, and I will ask those questions of our panelists as we go. You can also use the Q&A box, either one. Those are both located at the bottom of your screen. Okay, we're still getting people filtering in. I've got 1 minute past. We'll give it another maybe 2 minutes or so. Does that sound about right, Marlon? Because I don't want to start prematurely, but also I'm very mindful that we have a lot of material to cover, and I don't want that to be unduly rushed or have to skip things or any of that. This is always the worst part of any webinar, that silence as everybody's coming in. And I think we're going to go ahead and get started. There may be more people joining as we go, but all they're going to miss is the basic intro. So again, welcome. My name is Victoria Esposito. As I said, I'm the Advocacy Director of the Legal Aid Society of Northeastern New York. And thank you for coming to the CLE. It's going to be hugely important to have foreclosure defense as we move out of the pandemic and as people continue to suffer economic difficulties. I'd like to have the panelists introduce themselves. I'll be starting with Marlene Morales, who is a managing attorney here at the Legal Aid Society.
Hi, everyone. Welcome. I am a managing attorney in the Albany office at Lasney. I supervise the foreclosure prevention project out of the office in Albany, covering Schenectady, Rensselaer, Albany, Columbia, and Greene counties. And I've been practicing foreclosure defense since 2016.
Thank you so much. And Andy?
My name is Andy McNee. I work in the Saratoga Springs office of the Legal Aid Society and staff attorney here, and I've been practicing foreclosure defense for the last year and a half.
Thank you so much, Andy. And Kelsey, welcome back.
Hi, I'm Kelsey Racino. I'm a court attorney referee in the 4th Judicial District. My office is in Schenectady, and I currently cover foreclosure settlement conferences in Schenectady County. And I've worked for the court system since 2016, and before that I was a staff attorney at the Legal Aid Society in the Foreclosure Prevention Project.
Thank you so much for joining us, Kelsey. Tracy?
Tracy Peterson with the HUD-approved housing counseling agency Affordable Housing Partnership and with Better Community Neighborhoods. I am a certified HUD housing counselor, and I specialize in foreclosure prevention counseling and credit counseling. I've been a housing counselor since 1994. I started when I was 5.
Thank you so much, Tracy, and thank you for being here with us today. And finally, but by no means least, Shruti.
Hi, everyone. I'm Shruti Joshi. I'm a senior staff attorney at Legal Aid in the Foreclosure Prevention Project. I've been doing it since 2016.
Thank you. And I'm going to share my screen now because I neglected to send out the timed agenda with the materials that I sent yesterday, but here it is, and you'll be getting this with the materials afterwards. So Marlene will be giving an overview of the foreclosure process in New York. Then Kelsey and Andy will be discussing the settlement conference process specifically. We'll have Tracy talking to us about some of the options that homeowners can use to work out their problems short of foreclosure. There will be a short break at 12:20. Marlene will talk about pro se answers and how we can assist homeowners with pro se answers. And finally, I'll be talking about the ethics of limited representation in this context. And I understand that Judge Paulette Kirschko will be giving some closing remarks. And again, for those of you who joined a moment late, please feel free to put your questions in the chat. I'll be watching the chat box and the Q&A. And give me one moment. I'm so sorry. I always think I have this set up, and it always takes just a little bit longer than I expect. Here we go.
And Victoria, you could go straight to slide number 3.
I could if my PowerPoint were working. Marlene, do you want to hop in? Do you have the PowerPoint?
Yes, I do.
Thank you so much.
Okay.
Oh, wait. What can you guys see?
Nothing yet.
Okay. I apologize. There is always something like this. But I think we're there.
There we go.
And yeah, and you wanted slide 3?
Yes.
There you go.
Okay, so generally in New York, New York has one of the longest foreclosure processes in the country. If it were without the settlement conference, it could take from 6 months to a year. That's, if everything were perfect, ideal, but typically it takes a little longer than that, especially depending on how long the case stays in the settlement conference part. And it all begins with when the homeowner is 2 to 3 months behind on their mortgage payments. At that point, they're considered delinquent. And it triggers, especially for federally related mortgages, it triggers certain regulations where the mortgage lender has to reach out to the homeowner for what's called early intervention. First, by trying to call them, then in writing, sending what the options are to avoid foreclosure and so forth. If these communications fail, the lender is considering to proceed with the foreclosure. In New York State, under RPAPL 1304, they're required to send out what's called a pre-foreclosure notice. Victoria, would you be able to expand the graph? So This notice, it's statutorily required, so it requires to be mailed first in certified mail. It has specific content and format. And so it is statutorily prescribed and it must be complied strictly. It would say something about you're at risk of losing your home, you're this many days behind, and as of this date, this is how much you owe. They're also required to provide at least 5 housing counseling agencies within the vicinity of the home, or whichever's are closest to the home, for that homeowner to try to resolve the problem. And this is considered a condition precedent to suit. So if failure to comply with this notice will be grounds for dismissal. The next thing that the lender has to comply with, it's based on the mortgage document. So it's a contractual requirement of providing a notice of default, or in the graph you would see it's called an acceleration letter. It could have many titles. It could be an intention to accelerate. But in essence, it's 30 days given to a notice in writing, giving 30 days to the homeowner to come current. It has to state a specific amount that is good through the 30 days notice, and the method for payment of that amount. And it will typically say, let the homeowner know that failure to come current or reinstate the loan will result in the entire mortgage payment being accelerated. So basically that the entire amount of the loan is due unpayable. So finally, once those prerequisites are complied with, the lender then starts the actual foreclosure process by filing like a normal action, a summons and complaint. For foreclosure, there's a special warning that goes on the summons for the homeowner, letting them know that they're in danger of losing their home. But other than that, it's a typical action. It's served on the borrower of the loan and any other defendant. So that could be co-borrowers, guarantors, junior lien holders, even tenants who have a right to the property. And again, that goes pursuant to your typical CPLR rules on process service. Because of the coronavirus pandemic, there is also a requirement to give notice to defendants that they may have a right to more time to answer the complaint. So that also has to be filed and served on the borrowers. So once a homeowner is served with a summons and complaint, they have, again, as the general CPLR rules, they have 20 to 30 days to answer the complaint, depending on the method of service. However, in residential mortgage foreclosures, CPLR 3408 creates an assumption of a reasonable excuse for any untimely answers. So if the homeowner did not file their answer, serve and file the answers within that time period of 2030, they would still be presumed have a reasonable excuse. If they have not answered at all on the day of their first settlement conference, they will be entitled to another 30 days to submit their answer. So again, so I mentioned the settlement conference. In residential mortgage foreclosures of homes that are one to four family homes, settlement conferences are mandatory, and the settlement conference process stays the foreclosure. So that means that any motions filed before the conferences are held in advance. Again, it triggers the 30-day right to answer for the homeowner. Additionally, attorneys, from bank attorneys, or so attorneys' fees are not allowed to be charged to the loan account for the homeowner while they're participating in the settlement conference. So this is some of the advantages of being in settlement conference. And the purpose of it is to avoid foreclosure. So there are many ways that you can try to avoid foreclosure, and it's crucial at this point to get legal assistance for a pro se answer, or definitely work together with a housing counselor to avoid foreclosure. Obviously, if there is no meeting of the minds in the settlement conference, the referee will release it from that part that will lift the stay. I believe there's still a standing order in the Fourth Judicial Department that limits the time in settlement conference to 9 months, unless there are extraordinary circumstances. So if within the 9 months, the parties have not reached an agreement, it will get released in the Fourth Judicial Department. I don't believe the Third has any time limits. And I will go through the rest of the process a little briefly. So it depends what happens next. It depends whether or not the homeowner file an answer. So if the homeowner defaulted, the process is so much easier for the bank. They'll just have to file a default judgment, a motion for default judgment, and an order of reference. An order of reference simply asks the court to appoint a referee to calculate how much is owed on the loan. No notice is required to the homeowner because they've defaulted. If they've answered the complaint, then the plaintiff is required to file a summary judgment, and they'll also ask for an order of reference then. If successful, the referee calculates the amount due and issues a report, which later on the plaintiff will motion the court to confirm the amount due and do it and for a judgment of foreclosure and sale. If they're unsuccessful in the summary judgment, generally parties will settle, but it will simply mean a bench trial at that point. Once the judgment of foreclosure and sale is signed, it cuts off all title to the property and property rights for the homeowner and for junior liens holders who were made party to the action. However, the homeowner retains the right of redemption, so they can pay off the entire loan right up to just before the auction sale to avoid foreclosure. The referee is required to advertise the auction sale for 4 consecutive weeks until 2 local newspapers, and also issue a notice of sale to the homeowner, letting the homeowner know the time, date, and place. And it's for them to exercise their right. One point I would say is that for federally related mortgages, a homeowner can redeem by just reinstating the loan, and that's just based upon the mortgage documents. After the foreclosure auction, if the property sells for more than what was owed, and I've never seen this, but if it sells for more than what was owed, there are surplus money proceedings. So the homeowner and anybody else who had a property interest could make a claim to the surplus money. For most part, the property sells for less than what is owed. So the plaintiff is entitled to seek a deficiency judgment against the homeowner. They have to do this within 90 days of delivering the deed to the new purchaser. And that typically means that the homeowner is personally liable for that deficiency judgment, and they can face garnishment and other collection actions. Now, one of the important things that we tell homeowners is that throughout all this process, they retain the right of possession. They don't need to move out of their home. In New York, someone who is in possession of property must be evicted through legal process. So that means that the new purchaser must provide the homeowner with a notice to vacate and then proceed in a summary proceeding in the local court where the property is located to evict them. And that, in brief, is the entire foreclosure process. And now
Marlene?
yes.
We did have one question come in, and I believe
Oh,
this
sure.
was right around the time you were talking about mandatory settlement conferences.
Sure.
The question is, do you find, generally speaking, that lenders comply with these rules?
With the notice rules?
I believe it was notice, but also things like attorney fees and that nature of thing, not charging attorney fees during the conference proceeding.
So at this point, for the most part, they do comply with notice rules. We have to make sure that they, that they did. Still, for attorney's fees, we find that they still show up on the loan account. And it's not necessarily by the attorneys, but the loan servicers may not be aware of New York rules. So we definitely always scrutinize the loan account before a loan modification to make sure that there are no improper fees applied or put into the loan modification.
Thank you so much.
So you can go to the next slide. So right now we're going to focus on the settlement conference part. Right, so it's established by CPLR 3408. And I highlighted two words here. So it's applicable to home loans, to all home loans where a defendant is a resident of the property subject to foreclosure. Home loan has a statutory definition. I believe it's under RPA PL 1304. It had to be a loan, the proceeds of which were for residential purposes, either to purchase the home or improve the home. And it was taken out by an individual, a natural person. There may be more, but you can take a look at that. The other word that I wanted to highlight was defendant. So a defendant is in a foreclosure, it's not just the homeowner. It could be lien holders. It could be an heir with rights in the property of a deceased homeowner. It could be a tenant. So just to keep that in mind of what is settlement conference is applicable to. And again, the purpose is to try to avoid foreclosure and with the various options available to the homeowner. And with that, I am going to hand it over to the other panelists to demonstrate how a settlement conference would go. But before, I like to give everybody their first code word, or should we wait?
Marlene, before we get there, we have one more question, which is,
Okay.
does a reverse mortgage qualify as a home loan?
Yes, it does. It's actually the law has been, it was, now I don't remember when it was amended. And the 90-day, I would even go back, the 90-day notice, the pre-foreclosure 90-day notice now has specific language for reverse mortgages. That's also applicable for reverse mortgages. So yes, it's still, the definition of home loan has been expanded to include reverse mortgages.
Thank you. What I'm going to suggest is that we hold off on the first code until right before the break and then do the second one after the break.
Sounds good. So that I'll hand it over to Andy and Shruti and Kelsey.
Okay, what I would suggest is generally what we try to do, if at all possible, is we would try to speak to the client prior to the conference. And we're trying to work out now an ability to do that within the virtual conference world. I don't think we've got that technically down yet, but so typically I would meet briefly with the client. In this case, Trudy would be the client, and you want to know some basic issues before you go in to see the referee and the bank counsel. And so there's a lot of different ways this can go, but there's certain questions that you're always going to ask. The very first question I would ask the homeowner would be, do you want to remain in the home?
Yes, I do. This has been my home for over 5 years now, and I've lived here with my daughter, with my boyfriend, and this is the only home that my daughter has known. So yes, I do want to live here, and I want to retain this home.
Okay. Are you in the position right now to pay off the loan right away?
No. So I lost my job when COVID happened. I lost some hours, and you know, it was hard to keep up with my mortgage payments, and that's why I fell behind. And I need some time to catch up. I don't know. I reached out to my bank for a forbearance option, and they said that, you know, they don't provide that, and I don't know what to do now. And I then got this notice of a conference and foreclosure. I have no idea what to do.
Do we know if there's any federal connection to this? Is this FHA or Fannie Mae or Freddie Mac?
I don't know, but they said that, you know, they don't offer forbearance, so I imagine that it is not a federal backed mortgage. I don't think it is.
No, that's obviously something we can research. Anyway, okay. So I wanted to get a basic idea where you want to go with this. I also wanted to let you know this process is just starting today. It's not something that's going to be, you know, resolved in the next, you know, 2 weeks or 2 months. You're going to have time to make adjustments. You just have to take it seriously. So at this point, let's go in. We'll meet with the referee and bank's counsel, and you know, begin the process. Anyway, at this point, I think Kelsey should take over. She's the boss.
Okay, so we're just going to do a kind of moot settlement conference here. This is generally how I run conferences, and we do have standard forms that we use. So these are just the types of questions that you could expect pretty much across the board, at least in the 4th Judicial District. And do we have a bank attorney as well?
Well, yes, me. Sorry.
You. Okay. I mean, that's what I meant. Yeah. Yeah. Thank you. Okay. So good morning, everyone. If I could get your names before we get started here, that would be helpful. Ms. Joshi? Okay, I couldn't hear you. And Mr. McNee, are you here representing the homeowner?
Yes. We just met briefly, haven't signed retainer, but I assume that will happen. Yes.
Okay, and for the bank, we have Ms. Morales?
Yes, I'm here for Wells Fargo.
Okay, great. My name is Kelsey Racino. I'm the court attorney referee overseeing this conference. We hold these conferences to give you, Ms. Joshi, an opportunity to speak to the bank's attorney about any options that you might have to avoid the foreclosure of your home. I am here to see if I can help facilitate an agreement and to make sure that you and the bank are negotiating in good faith with each other. So that means that you're genuinely and diligently working towards some sort of a resolution, okay? While you're attending these settlement conferences, the lawsuit is on hold. The court won't sign off on any paperwork that would move the case toward an auction. If you reach an agreement with the bank during this conference part, it will discontinue the action against you and the foreclosure will be resolved. If we come to several of these conferences and it appears that you're not going to be able to reach an agreement, I won't schedule any more conferences and this file will go back to the assigned judge. And at that point, the bank can move ahead with its action. you can still negotiate with the bank at that time, but they are allowed to proceed forward, okay? Do you have any questions about that process?
No, I don't. Thank you.
Okay, great. So let me just ask you, do you live in the home, ma'am?
I do. Yes.
Okay, all right. And what is your goal for the home?
I would like to keep it.
Okay,
I want to
and,
keep it home.
all right. And are you employed?
I am. Yes, I'm back in employment. I lost some hours when COVID happened, but I'm now fully employed.
Okay, and so you're not self-employed, it sounds like.
No.
Okay, and do you have any other income for your household?
Yes. So I live with my boyfriend, and he works too. So he has a job, and he contributes to the household income. He takes care of some expenses in the house.
Okay. And have you filed an answer yet to the foreclosure complaint?
No, I have not. What is
Okay.
that?
So I'm required to tell you this by law that you have 30 days from today to answer the complaint. And your answer tells the court your defenses or your reasons the plaintiff should not win the case against you. If you don't put a defense in your answer, you might not be able to bring it up later. And to answer the complaint, you can fill out an answer form, which I'll provide to you. And then your answer must be signed, served on the plaintiff, and filed with the court. So here typically is when I would hand over an answer form and instructions and various other forms. And you have Attorney McNee here with you. So I cannot answer any questions about legal advice, but I could answer some basic questions about the package. But for more information about your foreclosures and your legal rights, you could speak to Attorney McNee, okay?
Okay.
So Attorney Morales, I'd like to get some loan information from you. First of all, have you had any correspondence at all, any loss mitigation applications submitted up until this point?
No, nothing received from the homeowner.
Okay. And do you have any idea whether this is a type of government-backed loan at all or insured loan?
No, this is not. It's a conventional loan.
Okay. And is the loan servicer Wells Fargo as well?
Yes.
Okay. Do you have the mortgage date and the default date?
The mortgage date, July 1st, 2015.
Okay. All right. And have there been any prior modifications in this loan?
No, no prior modifications.
All right. And will the servicer consider modifications or other loss mitigation options here?
Certainly if a full package is submitted.
Okay. And do you have the payoff and reinstatement figures today?
Yes, I do.
Okay.
The payoff is $256,293.48. And the reinstatement as of today, good through today, is $12,308.83.
Okay. Thank you. Ms. Joshi, do you have any idea of the fair market value of your property?
Don't know. Maybe between $180,000 to $200,000, I think.
Okay, so it sounds like it's underwater at this point. Given your express goal of keeping the house, it sounds like what we should do is probably set a submission schedule for you to get a blank application from the bank. And that is where the bank's going to ask for your financial information and have you submit that back to them so that they can review you for loss mitigation options. Okay. So Attorney Morales, I'll ask that you get that application, and should it go to Ms. Joshi or Attorney McNee first?
I would prefer it come directly to me and then.
Okay. All right. So why don't we have all correspondence regarding the application be through counsel for each side? I think that's easier for everyone. And that way we can keep track of what's happening. So by Friday, we can have you provide that application. And then, I don't know, 3 weeks from Friday, do you think you could submit that application to Attorney Morales?
Yes, I think so. I can get documents to Mr. McNee.
All right. And is that where the application should go? Should it go to your office?
Yes, it should come to council.
Okay. All right. And then I'm not going to go with actual dates here, but I would say basically within 2 weeks of that date to advise Attorney McNee of any documents that are outstanding, and then typically 2 to 3 weeks after that date to submit any missing documents. And then we would just set a date to come back.
Thank you.
You're welcome.
I had one question. It was my understanding that Wells Fargo was honoring the moratorium. Is that incorrect?
Oh, right. I did not do the administrative order portion of this. Okay, so there's another aspect of these conferences that are ongoing right now that's not generally typical to settlement conferences. So there's Administrative Order 15720 that says that in all residential mortgage foreclosure actions, the court needs to ascertain whether the borrower has had a hardship specific to COVID-19. And I believe Ms. Joshi did indicate that her hours were reduced and she did have some, some hardship related. And then I don't know if it's a conventional loan, but it is serviced by Wells Fargo. Is there any specific
Yes.
COVID relief that's available?
So New York State, well, it depends. If it's a financial institution that is regulated by New York State, there is a statute, banking law 9X, where they're required to provide information about or review someone who's had a COVID financial hardship for forbearance options. And the Department of Financial Services also issued regulations about that. The only concern is that the financial institutions are left to their own to decide who is eligible for such hardship option.
Okay.
So at this point, typically, because it would be a limited representation, the loss mitigation will be through a housing counselor. So we provide a list of housing counseling agencies to the homeowner or the defendant to contact, so that they can get the application in within the time limits that the referee has set. And with that, I leave that to Tracy to discuss what that entails. Do you want me to put the checklist up? Would that
Yes,
help?
please.
Okay. So just give me 1 second.
Can I talk while you're doing that?
Mm-hmm.
One of the great things about referring your clients to a HUD-approved housing counseling agency is that no matter what agency you go to, if it's a HUD-approved agency, there are no fees charged to your client for the services for foreclosure prevention. All of the counselors have the same training. They all have to have the same certification. They all have to have continued training so that they stay up to date on what is available and what can be done in the industry. So some of the documents, well, let me back up. When we meet with a client, we're first going to do an analysis of where they are income-wise to determine or help the client determine what their options are for retaining the house, but we'll also talk about non-retention options also. So the client has enough information to decide if they want to proceed. In the mock summary you just listened to, the house was underwater. We are required to let the client know what their non-retention options are and how that would impact them. We don't give legal advice because we're not attorneys. I did not stay at a Holiday Inn last night. I just happened to hang around with a lot of attorneys. But I'm really good at referring you out to an attorney for legal advice. On the screen is the checklist of what we require our clients give us. We will need a third-party release so we can talk to the lender and the lender's attorney. The hardship application is typically sent by the lender's attorney. Most housing counseling agencies will have copies of the hardship applications for each servicer. I've got them for a good 70% of the services I deal with. If I don't have it, I will be contacting the lender's attorney to get a copy of it. The other documentation includes proof of income, because the lender needs to know what income the homeowner has. So the most recent 30 days worth of pay stubs, if their income is derived from Social Security or pension, we need the award letters, and it's got to be the current year's award letter. Be aware that if it's pension or retirement, those those take a little while to get because they're usually mailed out to the client. So the faster you can advise them, if you got pension or retirement, call the administrator to get a copy of that letter prior to your appointment, the faster we can get that application done. If the homeowner has child support, they can use that if they choose, but be aware that the child support has to remain in place for at least 3 years. Oops. If part of their income is derived from rent, not only will we need the lease agreement or letter from the tenant indicating and confirming that they live in the house and they pay rent, the homeowner needs to show proof that they're actually receiving the rent. So we need the bank statements. And a lot of times homeowners who accept rent work on a cash basis. So we recommend that you tell your clients, start banking the rent money that you get so it shows up on your bank statements, because the lender will look for 2 consecutive months of bank statements showing that they have been receiving the rents. And no, they won't take receipts, because anybody can go to Office Depot, get a receipt book, and make out receipts and sign them. If they're using non-borrower income, that is someone who is living in the house, but they're not on the loan, that's acceptable, as long as the non-borrower provides the same documentation of income and residency that the homeowner provides. The lender will want the last or most recent 2 months of bank statements for all of their accounts, checking, savings, money market, CDs. They will also want the actual statements that are issued monthly or every 3 months, depending on what kind of account it is, not the transaction histories. So please stress to your clients, you actually need to go online, pull the PDF of the statements. And I tell people, just save it to your computer and send it to me via email, as opposed to taking pictures of it. That's just really annoying. Anyway, the most recent 2 years of tax returns are typically requested for FHA loans, VA loans, and USDA loans. Most other lenders are okay with 1 year of your tax returns, and it's the federal returns that they want. And the federal returns have to be signed and dated. They can be dated for the day that the client signs it, but there needs to be a live signature on that tax return. And they don't care about the state return. If the client is self-employed, they will require a year-to-date profit and loss, or the most recent quarterly profit and loss, and the last year's federal tax return. Most recent 3 months of bank statements. There are a few banks that will go unnamed that want 6 months of bank statements, because what they're trying to do is match up what the profit and loss says as far as income is concerned with what you're actually pulling into your bank account. And in that instance, they are going to want your business bank accounts. If your client uses their personal account for their business banking, they're going to have to go through those statements and identify all of the transactions related to the business. If the lender does not escrow for taxes, they will require the most recent year's property and school tax receipts and the tax bills. Those are probably the only thing that a housing counselor can get offline if they're in a city which allows access to that on their website. But if not, the homeowner has to go get it. If it's escrowed, the lender already has that information. Same thing with homeowners insurance. They want a copy of the current year's binder unless the lender escrows. The client needs to write a hardship letter, and the hardship letter needs to be very simple. What happened that led you to fall behind with the loan? Has the issue been resolved? And what is your intention on the home? It doesn't have to be a 3-page booklet. 1 page should be enough. And I tell people, keep it simple. The other thing they're going to want is an IRS 4506T. That is a tax transcript request form. They will also now require a taxpayer consent form. Other forms, if it's applicable, divorce decree, if you have a co-borrower and a borrower that are no longer married, and one of the borrowers has retained the house per the divorce decree, the lender will want to see that, and not just the part of the divorce decree that deals with the house. They want to see the entire divorce decree. So hopefully it's not too long. They also will want a quitclaim deed, and that quitclaim deed needs to be filed. If the homeowner or co-borrower has passed away, they will want a copy of that death certificate and the letter of administration, especially if you're dealing with an heir. And then for non-retention applications, it's everything above what I just said, and a copy of the listing agreement if they're looking to sell the house. If they have a purchase contract already, we want that too. And if they, and if it's available, the HUD-1 settlement or closing statement. Can I add one more thing? I actually like to get everything at one time. It's a huge amount of information to gather from a client. And most housing counselors will help their clients try to put this packet together as much as they can. There's just going to be some things the housing counselor won't be able to do. So the onus is always going to be put on the homeowner. But we are pretty adept at explaining to a client how to find this information if it's not readily available. It's helpful if you as the attorney can, because you usually retain a copy of the summons and complaint, while a lot of my clients tend to just toss it. I don't know why, but that happens. In any case, the mortgage and note is in the summons and complaint, and any modification that was done is in the summons and complaint. A lot of times I don't get that, and I don't have access to it because for some reason eCourts in this area does not put that information on eCourts, but they do it downstate. It's very weird. Anyway, I'm open to questions.
Yeah, and Kelsey, Andy, Shruti, do you have any additional comments about like good practices or anything that you would like to say?
I could just say that, you know, my goal basically for foreclosure settlement conferences is that the negotiations are as meaningful as possible. Most of that happens outside of the conference part. So, you know, part of that, making sure that they're meaningful, is making sure that homeowners have representation. So we have been inviting legal services agencies to come to the conference and observe, so that they are available to answer questions. And then we do always make referrals. We haven't had any bank attorneys object to that. And I think they also always prefer that homeowners are represented. It just makes the process go a lot more smoothly. And then a lot of the first conference is gathering information and trying to foresee any issues that might come up so that no one comes back to a second conference saying that they didn't receive letters telling them about missing documents, and there's some, failure of communication there, or, repeated requests for documents that have already been submitted. That happens a lot when it's just a specific issue with the document. It's not really the actual document itself. So looking forward, getting everyone's contact information, clarifying how everything will be submitted, and having everyone keep track of everything so that when we come back, we have better answers as to what's going on.
My only comment would be to emphasize, what's been said so far, and to say that to the extent humanly possible, every single piece of paper that's required is submitted with the initial application. So it minimizes problems down the line and makes it easier to get a positive answer, because I've gained the impression over time that the banks want to spend as little time doing the analysis as possible. And if you eliminate any questions, your chances of getting a positive result go up exponentially.
Thank you, Kelsey and Andy. I'm going to go back to the PowerPoint now and just make sure we didn't miss any major points. Question, do you bait stamp the documents? And I assume that's for Andy?
Well, most of the submissions that we make are done by email. And so that's our record. And we almost invariably will get a acknowledgement, thank you acknowledgement, basically from the law firm. Thank you, we received it, we're forwarding it to our client. So that's generally enough. And then in the few times we've had to fax, because that's the way we keep the record.
And it's this is off the record. It doesn't go to the court. There's a lot of personal information that gets transferred to the bank, including social security numbers and things like that. So unless Tracy, if you have any experience with that, I don't think they have a particular way for you to submit documents as long as they're readable and not pictures.
Yeah, they have to be legible. Things like the hardship request or hardship letter has to be dated. Any signature that needs to go on a form needs to be dated alongside it. And I usually submit via email because it's dated and I have a receipt that I got it, and it tends to avoid when you go into a settlement conference and the lender says we didn't get XYZ, and I can whip out that, yeah, you did, and here's the receipt, and you need to find that. Keep in mind that financials they expire, sometimes in 90 days, sometimes in less time. So financials should always be the most recent 30 days or the most recent 2 months, depending on what it is.
Thank you. And I have another question in chat here. Tracy's list of required documents mentioned it, but could one of the attorneys address the issues presented with divorces?
So we were going to make the homeowner a divorce homeowner, but it could get complicated. So the issue is that typically you have a husband and wife who purchased the home and they're both borrowers. So they're both personally liable on the loan. And then you have a divorce after the divorce, and there's only one party at the table wanting to retain the home and modify the loan. And the bank will ask for the ex usually for their information, even though they may be already not on title, they're not homeowners anymore. So issues come up that way. That's why they require a decree stating who has the right to the property and a quick claim deed from the ex to the defendant at the table. So it can get complicated when those things are not in place, and those need to happen in order for the person who wants to modify the loan to continue with the process.
Thank you, Marlene. And I have one question before I move us back to the PowerPoint. I took it down because I felt that it was better for everyone to be able to see all the conference participants. Andy and Kelsey and Tracy also, you all saw Shruti being interviewed as a homeowner, and she was obviously quite conversant with terms like forbearance and federal loans. What do you generally expect from a first interview with a foreclosure client? What kind of time are you talking about? What kind of follow-up questions and details are you likely to have to ask for?
For me, can I start?
Sure.
Okay. Once we do the financial analysis, it's pretty clear what the options are going to be. If there is income to at least make the normal mortgage payment, and they want to keep the house, but they don't have the assets to bring the mortgage loan current, the options are seek a modification on the loan. A modification allows the lender to take the arrears balance, capitalize it back into the principal balance, sometimes deferring a portion of the balance and rewriting the terms of the loan. Maybe not all of the terms, but generally it's a change of the maturity date, sometimes a change of the interest rate, sometimes a change of both. If there's sufficient income to bring the loan current within a 12-month or less period of time, a repayment plan may be the best thing to ask for. But it really depends on that client.
So from the attorney perspective, like if I am meeting a homeowner for the first time and I am going to represent them in a settlement conference, what I want to know, yes, what is your intention with the home? What's your financial situation now? When was the last time you paid the mortgage? Because if someone tells me it's been 5 years since I paid the mortgage, then that tells me something. That's and if they know, Andy did ask if they know usually if you tell them if it's FHA, most people will know what that means. So I may ask that, but not necessarily. I would recommend to ask the opposing counsel, the lender, at the settlement conference, if this is an FHA or Fannie Mae, Freddie Mac loan. So that way, you know. I think Kelsey did, so that was good. And if they have an idea of the value of the house, because then that tells you whether or not it's on the water and what to expect. And so, and generally, you'll tell them the timeline. It takes a long time. This is what you're going to expect. Speak with a housing counselor so you can submit your application. And you have 30 days to answer, and have you answered? And they'll probably don't know, just like Shruti said, I don't know what is that? And then you explain it then. So I think we're ready for unless somebody else has another question, we can move on to the loss mitigation options.
And there was just one comment that I'm going to flag up, which is that from a matrimonial attorney who says that he generally, in the context of a divorce, will recommend that clients speak with a financial advisor to make sure they can, in fact, afford to keep the home. And Marlene, you're looking at slide 5. Is this where you want to be?
Correct. And Tracy can go over the some of the options.
You need to,
Thank you.
there you go. A forbearance is the first thing that the lender will look at if the client has no income or they've had an interruption of their income. Currently, because of COVID-19, most lenders were offering a forbearance which allowed the lender to suspend the payment, not just reduce it, but totally suspend the payment for a specific period of time. When you come out of a forbearance, if it's 3 months, 6 months, in some cases 12 months, the lender will expect that all of those payments that they gave you a forbearance on are due, and you're going to be in a position to pay it. 90% of my clients are not in a position to do that. So if they have reinstated their income, we look at the next set of options. Repayment plans. Can you reinstate the loan in full? Are you able to submit a hardship application so the lender can review you for a modification on that loan? Again, modification allows the lender to change the terms of the loan to bring it current. Because at the end of the day, the lender really doesn't want the house. They just want to resume payments so that they can continue getting their interest and their money back. So loan modification is an agreement between the lender and the homeowner where some of the terms are changed. Hopefully it lowers the payment for the client, but it doesn't always end up with a lowered payment, particularly because if the loan is very delinquent, a lot of times when they readjust the escrow account, whatever they might have saved with the reduction in the principal and interest payment, it's canceled out by the increase in the taxes and insurance, which the homeowner has to pay back because it's not really the lender's responsibility. Next slide, please. Non-retention options include sale of the house, which is not on there, but it's a sale of the house where there's sufficient equity in the property where if it's sold, the lender will be made whole. Then there is short sale where the value versus what's owed is upside down. The homeowner finds a buyer ready, willing, and able and sells the house at its fair market value, and the lender agrees to not only accept less than the full balance in satisfaction, they typically agree to not chase after the homeowner for the deficiency. It's really similar with a deed in lieu of foreclosure. The homeowner voluntarily gives the house back or transfers title to the property back to the lender, and the lender agrees to waive the right to seek a deficiency judgment against them. With some loans, the protocol for the lender is they can't look or accept a deed in lieu unless the homeowner initially tries to sell the house. That's particular with FHA loans. You have to put the house on the market for at least 3 months. And if you don't find a buyer, then they can consider a deed in lieu of foreclosure. And then the last part is cash for keys. Usually that comes with a deed in lieu, but some lenders offer an incentive for you finding a buyer to buy the house if it's a short sale, where they will offer you money to vacate the house, leave it in good condition, and as long as you go, they will pay you. At minimum, it's usually $3,000. All of these options where there is a deficiency could incur a tax consequence for the homeowner because of IRS rules. So it's recommended that a homeowner talk to a tax advisor about the implications of a short sale or deed in lieu.
Right, because there is cancellation of debt. That may be considered ordinary income to the homeowner at the year that it was canceled, and also cash for keys. Any incentive is also income to the homeowner that needs to be reported, and typically they will receive a 1099 because of that event. So we usually, not usually, always tell them to go speak to a tax attorney or accountant.
Just an aside, that's hilarious when it's your ex-husband, just saying. Possible obstacles for workout options, just it's not affordable for the client, or they have insufficient income. Some modification or workouts get declined because the lender cannot mathematically come up with a payment within the guidelines that they have to follow to work within the confines of the client's income and the other expenses that they have. So housing counselors spend an inordinate amount of time with budget counseling for the client. Incomplete or late documentation submissions. Typically that gets your request declined. Doesn't mean you can't resubmit, but as a protocol for my office, I don't want to send in a hardship application that's incomplete, meaning it doesn't have all the core documentation that a lender needs in order to make a decision, because you're literally chasing after a client for documentation that they should have given you when they got the list of the documents you needed. And the lender gives you a short window of time to return missing docs, and then they have to call it. If there are judgments or liens or second mortgage, it usually requires that somebody has to go and request the subordination of the second lien or judgment, and that can be very difficult. I leave that to the attorneys to work out.
Yes.
Because they should have more fun than I should. Sometimes there are estate issues. I'm dealing with an heir because the homeowner has passed away, and no one took the time or made the effort to go to surrogates court and have themselves named the administrator of the estate. In that instance, there's really nothing I can do until they open up an estate and they've passed the title of the house to the heir that I'm trying to help assume the loan. The neat thing about working with an heir, though, is that there is a right of assumption that would allow them to not only assume the loan, but then request the modification on the loan. So the loan then is then put in their name and they've got a modification and they can start making payments again. But I work very closely with attorneys to do the legal end of it because not an attorney.
Lenders will not speak to heirs unless they have if there has an issue of letters testamentary or administration letters.
And then there are divorce or separation issues. I would recommend that you pay very close attention to whatever is in the divorce agreement, because I've had clients come by where the divorce decree actually said that the house had to be sold. So if I'm reading it and picking it up, you for darn well know the lender will pick it up. And that could cause an issue if you're trying to seek a retention option and there's a court order in an agreement that says the house is supposed to be sold. And then servicing guidelines. It is nice to get the information from the opposing attorney, but it is prudent to look up what actually the lender is allowed to do. And in some cases, you might have to go back to that pooling and servicing agreement to make sure that the lender actually did follow the correct protocol for the type of loan that you're dealing with. Possible other obstacles would be, okay, I'm looking at the same screen.
So it's the next one, it's for bankruptcy. So, I mean, Andy, I don't know if you want to cover that one. So I know you practice bankruptcy too.
Actually, I was going to say, that's an attorney thing.
Yeah.
I was basically the biggest decision you have to make here is, you know, if they want to retain the home, their option, you know, they've got to look at, okay, what's the value of the home? versus the amount of the homestead exemption. In the state of New York, we have pretty generous exemptions. So there's a possibility there. You could keep your home and be free and clear of your other obligations. And then if that's not the case, then and you want to keep the home, then you're going to have to go to Chapter 13, which is a so-called wage earner plan, which will take, basically you add everything that's owed and figure out if it's possible for the homeowner to pay off everything that's owed and make their regular mortgage payments going forward over the next 5 years. And either the math works or the math doesn't work. And if the math doesn't work, then, so that's the basic methodology that you go through in making that decision.
And as you see in the slide, it could be a tool to facilitate modification, especially when there are junior liens on the property that are impeding the lender from offering a final permanent modification to the loan. So if the circumstances are right, you may be able to strip some of the liens off the property that would clear the title for the modification to be recorded and the lender to be in first place. And it's another opportunity for loss mitigation in the Northern District. You can engage in loss mitigation within the bankruptcy context as well. And if everything fails, the homeowner may avoid a liability for the deficiency judgment.
And also it's great as leverage with lenders. If they realize, what will happen if they, don't bend a little bit more, it's sometimes very helpful in encouraging positive developments for your client.
Okay, so I think this is the break, Victoria. And I will give the first code word, and that's homestead.
And that's HOMESTEAD, homestead. We do have a couple questions in chat and Q&A, and we have precisely 8 minutes. So I think we should have a couple minutes for
Okay.
these. First, please address a situation where the mortgagor died intestate with heirs who take property as a matter of law, such that there is no reason for an administration proceeding.
So the issue is the lender. They want letters of administration before they acknowledge that you are an heir at law.
So even if the property would otherwise pass
Yes.
as a matter of law. And another, Shruti,
Go ahead,
yeah.
Shruti.
Just add to that, sometimes though, they will send the borrower or the surviving homeowner a survivor's in estate, like a survivor in interest letter saying that you've been recognized as a survivor in interest based on the operation of law, getting onto the property. And then you will have to go through the assumption. Some of the banks will do that.
Thank you. Another question, is an answer to the foreclosure complaint necessary if the defendant acknowledges that no payments were made for a period of time and there are no defenses? Is a notice of appearance sufficient?
Anybody want to tackle that?
Can't think of any reason not to make
I mean, settlement conference, you're making an appearance by participating in the settlement conference. And non-payment of the mortgage is always going to be there. Not sure about no defenses.
Kelsey, from your perspective, do you have thoughts on that? Do you have a preferred practice?
I mean, if there's absolutely no defense at all, then I would advise against filing any sort of frivolous,
Mhm.
answer to a pleading. But I mean, as Marlon was kind of going to, there are numerous defenses that I think she's going to cover. So it's possible that there might be something, but if the homeowner doesn't want to oppose the foreclosure, then that opens up other options to, I mean, maybe they don't want the house, or they could resolve the foreclosure in a different way still within the settlement conference part that doesn't involve litigation after the settlement conference part.
Thank you. And the other question we have pending is, please discuss modifications reducing balance to property value.
It almost doesn't exist anymore. Principal reduction was a thing during the economic crisis that began in 2008. And some lenders allowed for principal reduction when values just crashed. I haven't seen anything like that in the last 4 years. You can ask, but you've got to have a real good explanation as to why the lender should reduce what is owed. And then there's the tax implication if they agree to it.
I believe the flex modification, there is some set of facts where there would be some reduction in principal. I haven't encountered that yet. And I should explain the flex modification. So that's just the servicing guidelines for loans backed by Freddie Mac and Fannie Mae. And typically, whatever Fannie Mae and Freddie Mac do, they're the industry standard. So most conventional loans or owners of conventional loans will follow, not necessarily, but they will track whatever Fannie Mae and Freddie Mac do.
Thank you, Marlene. We have precisely 3 minutes if there are any other questions that can be addressed in 3 minutes. And a lot of what I'm hearing, and check me if I'm wrong, is it depends, which is about the most lawyerly thing you could possibly say.
Yes, depends upon the lender, type of loan, yes.
Any questions or clarifications? Otherwise, we're going to give you that extra 3 minutes in the break. I think we're fine for time. So we will resume at 12:30.
Yes, Ray. Well, look, since I've known you, you were getting, at some point, oh, so you got it at two different times.
Andy, you might want to mute yourself.
Oh, sorry.
That's okay.
Okay, I have 12:30 precisely, and we're picking back up at this point with assisting with the pro se answer. Andy, is this you?
That would
Actually,
be
Marlene.
me.
My
Okay,
apologies, Marlene.
so I will be sharing my screen for this part, Victoria, if that's okay. Okay, so what I'll do, I'll go through the form as I explained the different defenses that could be raised in a foreclosure, in a residential foreclosure. We have a pro se form, which is also given at the settlement conference by the referees. That's provided to pro se litigants. And I've pulled up a sample summons and complaint to just to show you where to look for some of the answers. So first, I just have the homeowner copy the caption of their summons and complaint. Hopefully they have it with them. It is required for both homeowner and lender to bring all of their documentation to the first settlement conference. That doesn't usually happen. If you're lucky enough to be in a jurisdiction where NYSEF, its foreclosures are required to be e-filed, that's another way to access the summons and complaint. Barring that, you would have to rely on the answers from the homeowner or from the defendant to complete the pro se answer. So first, let's talk about lack of standing. So for a plaintiff to have standing to foreclose on a loan, they must show that they have, well, if it's raised, they have to prove that they are the owner of the note and the mortgage. So the note is the evidence of the debt, the IOU, and typically the note is a negotiable instrument. The mortgage is the security interest. It gives it provides the home as collateral for that debt. So in New York, at the time of the filing of the foreclosure, the plaintiff has to have either be the owner, and they can show it by having physical possession of the note, or that it's been assigned to them. And a negotiable instrument can be transferred either of two ways, by physical delivery or by endorsement. And I will scroll down to where the note is. It's required for lenders, for plaintiffs to attach the mortgage and the note to the, if not to the summons and complaint, to what's a certification of merit. So here's the note, and here we see who it was given to. It was to the original lender or originator was Delta Funding Corporation. The plaintiff that we have in the caption is Wells Fargo. So they're not the same. So Wells Fargo would have to show that somehow they received it from Delta Funding. So as a negotiable instrument at the end, if there's space at the end of the document, there can be a stamp saying pay to the order of. If there's not enough space, and a launch can be affixed to that note, firmly affixed, and it would say pay to the order of Wells Fargo. So we have that here. We have what's called a special endorsement to the plaintiff. But that is not all. If I keep scrolling, there is a second launch, presumably affixed to this note, and it is paid to the order of blank by Wells Fargo. Now, this gives me pause because it seems that Wells Fargo negotiated or transfer this note further. So I typically like to look at the complaint and see what was alleged. And it will say something like this: plaintiff directly or through an agent maintains physical and or constructive possession of the note. And the note is either payable to plaintiff or endorsed or to a party that was delegated authority prior to commencement. This language is very equivocal, and we have another allonge. So I call into question whether or not Wells Fargo in fact had possession of the note at the time of commencement, and it didn't actually negotiate it further. So I would check lack of standing for this homeowner. Foreclosure cause, and I would also check the foreclosure cause of action, because once you raise lack of standing, that becomes part of the prima facie case for the plaintiff. Foreclosure, the threshold for foreclosure is very low. All the plaintiff needs to show is that they have to produce the mortgage, the unpaid note, and evidence of default. That's very simple. It's just an attachment of the mortgage, attachment of the note, and some evidence that the homeowner didn't pay. But once you raise standing, they also have to prove that they own the note and the mortgage that they're producing. This used to be a waivable defense. Now under, this is a very new statute, RPAPL 1302A, that's no longer waivable if it's not checked in a responsive pleading. The homeowner can raise it later on, except, you know, after judgment of foreclosure and sale has been entered. So I would check cause of action as well. Statute of limitations for residential foreclosures, it's 6 years beginning from any missed installment payment or from the entire mortgage debt if it had previously been accelerated. And the appellate division agrees that filing a prior foreclosure lawsuit by the plaintiff or a predecessor of a plaintiff with standing will accelerate the entire loan. So if you know, or you may ask the homeowner, have you been in foreclosure before? That may trigger this question, and how long ago was it? Was it more than 6 years? If it was, you may have a statute of limitations defense. I would also look at the complaint and see the alleged default date. And usually it would read something like this, that so Jane Doe and Joan Doe defaulted on their obligation by failing to make payments due on June 2019. Because it hasn't been more than 6 years, I wouldn't check this defense. Another place that you may want to look is the 90-day notice, pre-foreclosure notice, because there they tell you how many days you're delinquent. And while the complaint may say they're only in default since June 1st, 2019, your pre-foreclosure letter may say you're 2,190 days behind. So you try to find inconsistencies, and if in any of those places you find that it's more than 6 years, you should check it, because if you don't raise it, it is waivable. Then next is the service of process. That is the usual as it's any civil lawsuit. And typically, again, I would look at NICEF to see if there's a filed affidavit of service. If you don't have that option, then it's just asking questions to the homeowner on how they received the commencement papers. And I would also advise that they have 60 days to file a motion to dismiss based on service. Otherwise, they lose that defense. They waived it. And this is where the settlement conference and normal civil practice collide, because you have 60 days, but you also in 60 days, you're supposed to have a settlement conference, which stays everything. So you may be in a position where you file a motion to dismiss and it's held in abeyance because you're in settlement conferences. So next, another defense has to do with notice of default or the acceleration notice. So that notice that is required by the mortgage documents. Again, it's typically relying on what your client, the client tells you. If they received it, I usually describe what it is and if they ever receive it. And if they say no, you can have them check that. There are special prerequisites for reverse mortgages, which I'm not going to spend too much time on, but they're condition precedent to the lawsuit, especially the idea. Most reverse mortgages are backed by HUD or FHA, and before a lender can foreclose or even accelerate the loan, they must seek permission from the Secretary of HUD. And that has to happen before the foreclosure is filed. So if that's not complied with, it's a ground for dismissal. Also, there's just got to be notice, specific notice to the homeowner with its own requirements. So, and we also like to raise a public policy defense for reverse mortgages, given that we're dealing with senior citizens in their homes and in situations where the reason for foreclosure, it's because they failed to send a postcard back to the lender saying they're still alive and they're still in the property. So there are some good policy reasons why foreclosure should not be the remedy. Here's the 90-day notice, again, the requirement by New York State law under RBA PL 1304. Hopefully it's attached the complaint. To this complaint that I pulled up, they didn't attach it. Sometimes they will attach a copy of the 90-day notice, which is nice, because you actually get to see if they comply with the content and the format and the type of service, the manner of service. But typically it's just asking the homeowner if they received that type of notice or if they recall that they received it. Another requirement for the 90-day is that lenders must file with the Department of Financial Services, DFS, just proof that they've complied with that provision. And it has to be within 3 days of mailing. So that's another thing to double check, because it's strict compliance. There is a third department case where the lender was delayed by 3 months. They mailed it, but it wasn't 3 months later that they filed with DFS, and they dismissed the case because they didn't strictly comply with that law. Another requirement, which I don't think we've covered, summons and complaint in a residential mortgage foreclosure must be accompanied by help for homeowners in foreclosure notice. And this notice it's bright color paper. bold, big letters. It's statutorily prescribed. So the content and the format has to comply with the statute, and it has to be served with the summons and complaint on the borrower, on the homeowner. This is also a condition precedent to suit. So if it's not complied with, it's grounds for dismissal. Another defense that we see is the pending foreclosure action. So sometimes there will be a prior foreclosure action, and perhaps they settled it with a modification, but the bank's attorney never finalized the process by discontinuing the action, and the action is still pending out there. That was something that you would bring up as a defense, that you cannot have both action at the same time. Again, that requires a little research, but you could also ask the homeowner. And next, I have the Real Estate Settlement Procedures and Act. And this is the early intervention requirements that I mentioned before on the overview, so it's federal regulations that require the mortgage servicers to reach out to the homeowner within a specific period of time. So typically I would just ask, have you received calls from the lender when you first, fell behind? Did they try to call you, or have they been sending you letters telling you what you can do to save your home? And you go by that and see if there's something that the homeowner can raise as a defense. This would be more of a counterclaim. Then there's another RESPA defense that can be raised, a counterclaim. It's a pre-foreclosure review. So under RESPA, the lender has to wait at least 120 days before filing a foreclosure. And it's 120 days from a missed payment. So at the very minimum, they get 4 months before they're facing a foreclosure. The other provision here is that the lenders are prohibited from what's called dual tracking. So on the one hand, they have the requirement of early intervention and trying to engage in loss mitigation with the borrower. But they cannot then also file for foreclosure. So they have to do one first, then the other. If they're engaging in dual tracking, that's a counterclaim that the homeowner can bring up. So for mortgages that are FHA, they have specific requirements, and the courts have determined these requirements and regulations, federal regulations, to be conditions precedent to foreclosure. Specifically for FHA loans, there is a timeline. Before the end of the second month, notice have to be sent to the homeowner. If they're within a certain distance from the homeowner, there's got to be at least an attempt to have a face-to-face interview with the homeowner, and evaluation for loss mitigation has to happen before the fourth month of missed payment. And they have to wait at least 3 months before commencing a foreclosure action. So there are additional protections for homeowners with FHA loans in this. And again, more ground for you to ask the homeowner to see if these steps have been taken and perhaps raise it as a defense. And so I mentioned the certificate of merit requirement, and this is a came from the foreclosure crisis, where a lot of plaintiffs' attorneys were filing foreclosures without having proper paperwork, and it turns out that the plaintiff didn't have standing to foreclose some homes. And there were some unlawful foreclosures. So in that scenario, so now it's required for the attorney or the law firm to actually certify that they spoke to someone at the bank, and that actually I can show you the certificate of, and then they have reviewed the documents and they believe the plaintiff has a right to foreclose. So an attorney has actually to sign this document and file it with the court and state that they reviewed the documents. So requests for judicial intervention, this wouldn't be a problem for someone who's at the settlement conference. Presumably that's already done. That's what triggered the settlement conference. So that wouldn't be something that you check. But for homeowners who have not been in haven't received that notice yet, and they're still in the shadow docket, that would be something that you would check. Attorney's fees, I also would check, because if the homeowner eventually hires an attorney and they are successful in defending the foreclosure, they invoke that reciprocity in the law. The note and the mortgage provide that reasonable attorney's fees have to be paid by the borrower. So this allows the borrower, if they defend the foreclosure successfully, to get their attorneys, the attorney's fees as well. I'm not going to spend too much time on this one. Excessive interest and fees, that has to do with the fact, if the homeowner had a prior foreclosure and there was some lack of good faith, negotiation, or delay on the part of the plaintiff. And then excessive interest, that's probably more what you would ask the homeowner. When was the last time you paid? And have you talked to the lender? And then you determine, like, how long has it been since that happened, and the requirements for loss mitigation. And if it's been 2 years and they're just now waking up to file, in the meantime, the homeowner has accrued all this excess interest. So that might be something to look into. And something that we, especially with heirs, we talked a little bit about heirs being defendants. Actions commenced against a deceased party, that's a nullity. Especially lenders are supposed to do their due diligence and search surrogates court and so forth. So they may be suing a debt borrower, and that's certainly a defense to raise. And payment or partial payment, usually we have homeowners say to us, oh, but I've been paying, I've been sending payments, and just 3 months ago, they stopped accepting my payments. So that might be something that they might check if they're claiming that they have been making payments and the amount due is not correct. And this is just extra space for the homeowner to explain their situation or to give a little bit more detail on the defenses. I would say especially a notice of default, because it's a contractual condition precedent, it requires a little more specificity. So a few words about that would definitely help to survive summary judgment. And other than that, it's the matter of having the homeowner sign the document and verify it, and notarize their signature. And
And
I am
Marlene, we do
open
have
for-
one question. I'm so sorry. I
No, go
think
ahead.
we were reading each other's minds there. So the question is, it appears that the general 90-day notice requirement for all home loans under RPAPL 1304 sunset on January 20th of 2020, and that effective January 20th of this year, it only applies to subprime and non-traditional home loan foreclosures. Is this correct?
No, so that was changed. Now it's permanent.
Excellent. Permanent is good.
I think,
And,
I mean, I have to double
go ahead.
check. I think it's made permanent. But I have to go check again.
Thank you. Any other questions? Okay, thanks, Marlene. And I'm going to move on at this point to the ethics section, which I know we're all super interested in. Let me get the PowerPoint back up. And Marlene, may I ask you when to get ready to share the limited rep retainer and answer when I asked you to? And I'm skipping ahead here. And, oh, goodness. My apologies, everyone. I am just going to whip right through here. So this always comes up in any context where we are going to do some form of limited representation. Here, of course, what we're looking at is agreeing to represent the client only for an answer, or in some cases an answer and the settlement conference. That's not all the representation the client may need for for a full foreclosure. It's not the same as agreeing to represent the client in litigation. This is ethically permissible, but there are certain things that we need to be careful about. So I'm going to direct your attention first to Rule of Professional Conduct 1.2c. This specifies that you can limit the scope of representation if three conditions are met. Is the limitation reasonable under the circumstances? Has the client given informed consent? And have you provided necessary notice to the court and or opposing counsel? So I'm going to take a minute to just unpack these with respect to foreclosure conferences. And please, of course, ask any questions as I go. First, is the limitation reasonable under the circumstances? And in a case like our Attorney for the Day program in foreclosure court, that's all we're there to do. That's all we represent to the clients that we're there to do. That's all we represent to the court that we're there to do. And we don't say that we can, for example, represent for foreclosure, but the goal is to see if we can help the client file that pro se answer and perhaps work something out through the settlement conference process. So under those circumstances, that is a reasonable limitation. Now, has the client given informed consent? Marlene, could I ask you to share the limited rep retainer, please?
You want just for the representation?
Yes, please. Thank you. Okay. So what you'll see, oh, perfect. Thank you so much. So what you're going to see right here is that this is the retainer that we would use, and it specifies that the representation is limited to the appearance at the settlement conference and negotiations with the bank only related to this particular foreclosure lawsuit index. Now, this is our standard retainer filled in for limited purposes, and you'll see that this is something you would go through fairly carefully with the client. This is something where you don't want any gray areas. You need to make sure that the client understands that if there is litigation above and beyond the settlement conference, if there is a motion for summary judgment, we are absolutely not agreeing to help with that. And this is the kind of disclosure that is required, in my opinion, by the ethical rules. Thank you, Marlene. And our usual practice is to go through and essentially read all the, there we go. And essentially read all the provisions to make sure that the client understands that, and that is something, the limited nature of the representation, that you would want to highlight. And finally, where necessary notice is provided, often you'll see a limited notice of appearance. So, if you file a notice of appearance, it'll be something along the lines of appears solely for the purpose of settlement negotiations, foreclosure conferences, that nature of thing. Now, I know you all know this, but I felt it was important to underscore this. Every single other ethical consideration is the same. You have to be competent to do the thing. You have to keep client confidentiality, that nature of thing. There is one exception in this context. Rule of Professional Conduct 6.5 carves out this very limited exception to conflict of interest. And what this means is that if a lawyer is providing short-term legal services together with a legal services organization, and there is no expectation that the representation will continue, the attorney can help the client on the spot without doing a full conflict check. If the attorney does not have actual knowledge at the time the representation begins that he or she or his or her firm has a conflict. And there's a lot to unpack there, so let me just say that again. The attorney is conflicted out of the representation only if, at the moment he or she sits down with that client, he or she knows that the attorney or the attorney's firm has a conflict. So you can see this is a limited exception to the conflict rules, and it's also necessary to allow for sort of a field intake, attorney for the day type program. We do this at Legal Aid with eviction cases. We do this with foreclosure cases, and it's really helpful for our volunteers. Now, if the attorney decides the pro bono, and I'm talking here about pro bono attorneys to be clear, if the pro bono attorney continues the representation further, so let's say that it's a very compelling case, the pro bono helps file an answer, the pro bono appears at maybe a settlement conference, and they're unable to reach a workout of some kind, and it goes into litigation. This is, of course, beyond the scope of what the attorney originally agreed to do. But let us say that this pro bono says, oh, this is a very compelling case, I'm happy to litigate on behalf of this client. Well, what you would need to do is a couple things. First, as a matter of practice, that attorney would want to enter into a totally new retainer with the client, because that spells out what the rights and responsibilities of each party are. And in the event that this client, that yes, in the event this attorney has a conflict with the client, they are required to do the more full conflict check once they accept the case for further representation. Any questions about that? I feel like that was a little bit backwards as I stated it, but the short version is you're somewhat protected as long as you're only doing limited representation for short-term legal services together with a legal services organization, or a few other exceptions. But as important here, it applies to a pro bono attorney working with a legal services organization. We've talked about helping people with a pro se answer. And there's been a lot of discussion, a lot of litigation, a lot of ethical opinions on this issue. What you'll see if you read about the need for more access to justice is a lot of discussion about unbundling legal services, as it's called. So basically, taking apart full representation and doing limited representation, assisting with pro se pleadings, that kind of thing. And there's a lot of variation about whether it is acceptable ethically to draft pleadings for pro se clients. Why is that? Well, as you know, the courts will generally give a lot of deference to pleadings that are drafted and presented by pro se clients. The question then becomes, let us say this client presents a pleading and gets that kind of deference, but actually also has had access to the expertise of a lawyer in drafting that. Is that acceptable, and is it fair? New York, so far as I could tell when I prepared for this, New York has not revisited this in about 10 years. And New York's been a little bit over the map. Back in 1987, which so far as I can tell is the first specific ethical opinion about this, and you've got these references in the PowerPoint, which we'll be sending around. The New York City Bar said it was okay to ghostwrite pleadings for a pro se client, or pro se plaintiff, pardon me, with a general disclosure. So just kind of like, hey, an attorney wrote this. A few years later, NISBA, in opinion 1990, said that this was permissible. So you can do this, no problem. But the attorney must specify his or her name in the disclosure. So that's a little bit more rigid, if you will, and errs a little bit more on the side of disclosure. The most recent opinion that I could find was from the New York County Lawyers Association. And this essentially says, well, you know, there are some circumstances where it may be okay not to disclose that you ghostwrote. But as I recall, in that opinion, the County Lawyers Association said, but, you know, to be on the safe side, you should always disclose your involvement. So, Marlene, could you pop the pro se answer form up again, please?
I apologize. I think I,
You're fine.
okay.
Thank you so much. So what we're looking at,
Oh,
brilliant, thank you.
You want the bottom?
Yep, that's exactly right.
Okay.
So what you're seeing here is,
You're not seeing it. There.
yep, so this is, and what you can see is we've just popped a footer into the document, so it appears on every page. This document was prepared with the assistance of, and there's a blank for the pro bono's name, an attorney working pro bono under the auspices of a legal services organization. Such assistance was limited to advice and counsel to the client and the preparation of this document for pro se filing in accordance with Rules 1.2C and 6.5 of the New York State Rules of Professional Conduct. You can see this lays it all out. here is the individual who helped this client. Here is why this falls under that little exception to the ethical rules. Here are the parts of the ethical rules that allow that. And here is the limited nature of the representation. This is, in my opinion, best practice. And you can see that this is an older form. It also has this general notification on it, prepared with the assistance of counsel admitted in New York. As you can see, there's not a lot of agreement as to what is necessary as far as the disclosure and when and whether the disclosure is necessary. In my opinion, you're really better off doing the full, very specific disclosure. Because, honestly, it takes you 2 extra minutes, and it could help you stay out of a world of trouble, depending. Thanks, Marlene. I'm going to reshare my screen and try to start the PowerPoint again. And there we go. And I want to emphasize a couple things. Number one, the ethical rules that would otherwise apply to any answer do still apply. So you have to be able to discharge your duty to investigate what the client is saying. You have to file in good faith, as does your client. You still need to explain the lawyer-client relationship. All those things, none of that changes just because you're helping with a pleading. If you have reason to doubt something your client is telling you, remember that your name is going on that as a drafter of the pleading. So you're dealing with people in crisis. You're dealing with people who are trying to put together a lot of paper. You're dealing with people who may not really understand exactly what is happening. And, those are all things to keep in mind. I'm not saying that you have to see every piece of paper. I am saying that you have to investigate the claims and defenses just to the extent possible in that limited circumstance, just the way you would any other answer. So this is the sample disclosure language again, so you have it. And I think what I would say as far as limited representation, there's a lot that's been written about it by commentators, by scholars, by researchers. I think that it's helpful for clients in that some assistance is always better than no assistance. I think that we, especially as legal services attorneys, there's not enough of us to go around. There's not enough of our pro bono volunteers to go around. And surely it's more helpful to our clients than not to have someone sitting in that negotiation with them, or to have someone helping them articulate what their defenses are. So I don't think any of us thinks that this kind of limited rep is ideal, but it is absolutely better than nothing, in my opinion. Just please be aware, that there are some ethical rules that cover that disclosure of the representation, of the drafting, of the limited nature of the appearance are really important. I'll just note that we see this a lot when we draft pleadings in other arenas. You get a lot of correspondence from the court to our office that shouldn't necessarily come to us once the pleading is drafted or the appearance is over and the representation has ended. So that's why I think it's a good idea to ensure that whether it's in the notice of appearance, whether it's on the record, whether it's right on the pleading, you make sure that the tribunal and opposing counsel and and the client are well aware that this ends your involvement. Does that make sense? And do people have questions or further comments, perhaps most especially from the attorneys on the panel? I'm going to speak to Andy and Shruti. You both do limited rep with some regularity. Is that correct?
Yes.
Correct. Yes.
And do you have any particular pitfalls that you've run into with respect to explaining that to clients, or to, with respect to clients understanding what your representation and involvement are going to be? Do you have any best practices for helping clients understand that?
Well, I would say that, when we go through the retainer agreement, I try to lay all this out and explain to them, what I am going to be able to do for them and what I'm not going to be doing. And they are generally very appreciative of what we are able to do for them. And I also make clear that, if later on in the process, they are served with documents, they can reach out to me and we can take a look at it. We can't make any promises, but we try to stay engaged as far as that's concerned. So if there is an unusual case, we have an ability to revisit. But as a general rule, they seem to be appreciative and they understand the limitations, but appreciate the assistance.
Shruti?
I would just add that, we try to explain to them that we're representing them through the settlement conference part, which that's what, our limited retainer does. And for the purposes of what they're trying to achieve at that moment, that is sufficient for representation. So that kind of assures them that they will get the representation they're looking for. And then explain to them that it would be sort of a step retainer if we decided to further represent them. We just don't do it at the get-go because of funding. I try to explain to them, it's funding issues and we're limited resources. So, and like Andy said, they understand. And I think they're looking for representation in the conference at that time. So they're okay with not being represented in the future. I don't think they're even thinking about that, but yes, they do appreciate the help.
Thank you. So we have a couple questions here. First, this is from Judge Kirschko. Would it make sense to file a consent to change attorney form after the representation has ended? Yes. The reason I'm a little bit questioning this is simply because I feel like changing attorneys isn't really what's happening. It's more like the representation has ended. It's not even more like, it is that the representation has ended. I have never done this. I don't think if I've done limited rep, and it's been a while since I was in a courtroom. I would say that spelling out in the notice of appearance that this is a limited appearance for the purposes of settlement conference and assistance with a pro se answer only probably does the same thing with a little bit more clarity.
I could jump in with this. If it is an ISIF, it's an e-filing jurisdiction, there's a specific form that you can file to announcing the termination of the limited representation. And that has to be served on all parties, whether or not they appeared. And so that there is a way if it is an e-filed jurisdiction.
Thanks, Marlene. And we have another question. Shruti, yeah.
Sometimes I have done a substitution form with clients to transfer from being represented to being pro se, but that has also been when I've ended representation sooner than the termination date of my limited notice of appearance. If they filed a bankruptcy and now I don't have anything to do on the case, I have filed a substitution form, so that just notifies the court and the opposing counsel that they're pro se.
And in the ordinary course of things, you just allow the limited representation notice of appearance, or however you handle it, to speak for itself?
Yes.
And another question, if you assist, do you take responsibility for filing? The reason why I ask, this questioner adds, is that I'm saddened to say that sometimes pleadings are added to after you're presented with what appears to be a final draft. So I think what as I understand the question, it's what do you do about filing, and particularly in the case of pleadings that need to be amended in some way. Is that correct? And I will say most of so I am not these days practicing in foreclosure. But
We usually don't see amended pleadings except for the times where they wake up and see, well, this is a deceased borrower. Now we're going to name the heirs, or they're motioning for permission to serve by publication, and then amended pleadings will be served again. That's the only, I don't know, I'll leave it to Andy and Shruti.
No, I concur. That's the only time I've seen amended pleadings come in.
And I don't know what your practice is about filing. I can say that in some of the areas within legal aid where we are providing pro se assistance, what we do is we give the clients filing instructions and have them do the filing themselves. I don't know what your practice is, Andy, Shruti, Marlene?
We have the courtesy of serving it for them since they can't do it themselves. That was pre-COVID when we had them in the office. It just made sense to notarize the answer and put it in an envelope and send it out. But now it's been the practice to just send instructions on how to do it themselves.
I actually do it the other way. I find that I do have to get their signature, but for me, it's a whole lot less worry to it's electronically filed anyway, and I can mail it to opposing counsel. To me, it takes me less time and less worry than if I just do it myself, but that's just me.
And the questioner about, the person who had the question about filing said that what he meant is that sometimes pro se litigants do take it upon themselves to add defenses and so forth, even if you instruct them not to. So I think the question is, so therefore, there may be some concerns that what gets filed with your name and that disclaimer is not going to be what you put together. Thank you for the clarification. And thoughts on that? Have you seen that happen? Do you have an approach for that? Is that another benefit for doing the filing yourself? I'm seeing some very, very emphatic nodding here.
You read out the verification to the client as well, saying that, anything that you say in the pleading is true to the best of your knowledge. You're not lying here. There are notices that most of our clients don't remember having received. So we tell them, you're doing your best. If you don't think that you received a notice like that, sure, raise the defense, but you're not going to do it if you know that you received something where you were served properly. So I would just, do that again.
Mm-hmm. And in that situation, I would advise on defenses that they can raise instead of if they're going to do it on their own. So these are possible defenses that you may have.
Sure. And that would be the kind of thing where perhaps the person, as you said, couldn't find a piece of paper, wasn't sure about it. And is that something that you think is best practice to put in writing for the client?
Usually I do that if it's only an advice case where we're not doing limited representation. Yes, I would put it in the closing letter.
Mm-hmm. And the reason I'm thinking that from an ethics standpoint is, again, your name is on that pleading as having assisted the client. So Are you on the hook for something the client adds? No, not necessarily. Do you want your name associated with something that is really kind of out there? Not necessarily. And we have one comment, and then I think we're ready for Judge Kirschko to wrap up. Comment is that from this listener, is that she has seen it as common practice. I'm sorry, I'm not sure that was English. She has seen this happen routinely, where a client decides to end their relationship with their attorney and go pro se, and that would in fact be done by a notice of consent to change attorney. Now, I'm not sure whether that would have been in a limited rep circumstance, or whether it was, a parting of the ways that was not expected or intended between the client and the attorney. Judge Kirschko?
You are muted, Judge.
Thanks for inviting me. And I was saying, this is by far the most informative continuing legal ed training I have been to in probably 20 years. The written material is amazing. Kudos to all of you that put this together, co-sponsored it, interested in it, all the attorneys. I see a lot of familiar names out there, which is very encouraging. And for those of you who don't know me, I'm a family court judge, but I also have 100% of the foreclosures in Warren County. And when I was in private practice, part of my practice was actually I represented lenders, and I was the bank attorney, and I used to do commercial and residential litigation for that. But it's been a long time, and it's just changed enormously since I was doing this kind of practice even through bankruptcy court. In any event, I just thought I would lob out maybe an interesting idea, that maybe you take a therapeutic approach to this as well, recognizing that these folks are in crisis and they are experiencing psychological trauma of some sort, whether it resulted from a death or medical issues or separation, job loss, pandemics, whatever it was that led to now this trauma of losing their home. And to many homeowners, a home equates with safety. Maybe destigmatizing it with them, that they're not alone. This is millions of Americans are going through this. And then assuring them that if you help them make a plan, that is a way to gain back control and to get back their safety. I do think that, this is hard work, and just by the PowerPoints alone, it's highly specific, all the notices, all the things that have to happen. And I would say this training should be recommended for judges and referees as well, because I think it puts them more on notice as to when legal representation really could be helpful. Sometimes I think those of us on the court side might be making decisions for people that really we shouldn't be making, in the sense that, you sitting down with them and maybe even pre-screening before the initial meeting. It's very hard to just throw up your whole life in a meeting in 5 minutes, and certainly virtually on top of that. So if there's any way that you can address this in advance with some privacy, maybe where people could share with you truly what's gone on. All of us have jobs to some extent as attorneys where people vent and you have to let them talk a little bit. But it's just so impressive and so exciting to see that we have people that are so smart out there that are actually advising these homeowners. Communication wise, we are e-filing now. And I will say that a lot of times it just started for us. The chambers are always in the dark as to who's on, who's off, and maybe even the referees a little bit too, with these conferences. And so we are always nervous. I speak for myself, but as a judge, that we don't want to leave somebody out if they actually were there representing people. And so we do look at the notices of appearance. And particularly what I found now is that we have these new administrative orders requiring additional conferences. And depending on what you call it, if you've done an appearance at a settlement conference and your notice of appearance says that, The question is, do you have to come back and do it again now that we have to do these additional conferences? So there's a lot of questions out there on representation, and I really think the ethical portion of this training was excellent for exactly those reasons. And it's just helpful if in doubt, just notifying the chambers, no matter what, you know, you're done, you're off. It's just to have something on file. It's just, it's important because I think it also protects you too. So I just want to say thanks to everybody. It's just amazing. And this was a great, great training. So hopefully it's going to be made available to others.
Marlene? Marlene, really, this was all you coordinating this. So if you have final words for us, or if anyone else does, and please be assured we will be sending out the PowerPoint.
Yes, all the materials will be sent out, and some of the things that we showed you today as well afterwards. But if you have questions, feel free to reach out to me. And I hope, you know, that this was useful, and I have encouraged some people to take a case.
And as a reminder, thank you for that reminder. As a reminder, for those of you who are private attorneys, this is a free training on the condition that you accept pro bono cases from us for foreclosure settlements. So thank you. Oh, thank you. Final code. Thank you. The final code is redemption. REDEMPTION, redemption. Thank you. My apologies. I was so excited about limited representation and ethics that I completely forgot to give the code. So you can sign up through Legal Aid's website, and that's a link that we'll be sending out with the materials. Thank you all for being here today.